The biggest impact we're seeing AI have on all the work that you do is that it's creating opportunities for more content creation, um, and faster content creation, perhaps, but it's also creating questions around intellectual property, liability, and how to have these conversations internally at your agency and with your clients as well. So, what I want to cover with you today in the time that we have together is three basic things. And the first is sort of a high level summary or review of where we stand, what the state of play is with intellectual property protection that surrounds generative AI created works. What is the latest as we sit here in November of 2023? And I'll give you my viewpoint on where I see us headed. And I'm excited to maybe answer some questions about this during the Q&A period if we have time. Um, what I see as the fundamental business intellectual property issues that actually face you as an agency leader every day when you're trying to figure out how to incorporate this generative AI into your workflow. And then I really want to focus on some practical steps that your agency can take immediately after you listen to this session internally at the agency and in interactions with your clients, your contractors, your vendors to limit your risk while you are not causing any drag or slowdown in your adoption rate of AI. So let's talk a little bit first about where we stand today in terms of IP protection and IP ownership surrounding any work or deliverables that's created using generative AI. I think most of us are familiar with the Copyright Office's stance in the United States around machine created work. Currently, the position of the U.S. Copyright Office is that only human created works are subject to copyright registration and protection under the copyright statutes and all the things that that enables, like the right to collect damages, the right to send cease and desist correspondence and have that be effective. Um, but questions that we get a lot at my firm are in the vein of we understand that machine created work isn't protectable under copyright law, but what about works that maybe have their origin in generative AI, but that also contain human created variables? Perhaps we used AI as a starting point at our agency, and then our creative team supplemented that or augmented that or edited it or polished it, or maybe we only used it for inspiration and really just as a tool. What about that work? And does that change the copyright position at all? And I'm going to tackle the second question first, which is that what about the position that just like photography or software code, that generative AI platforms are just tools, just like these other things. And so, why should that impact the copyright status? I'm going to tell you that so far the Copyright Office isn't really impressed with that stance. They clearly see a dividing line between human created work and machine generated work in terms of its copyright protectability. But that doesn't necessarily settle the question completely, particularly when you have these hybrid works or when you might have used generative AI for initial drafts or for inspiration or for research.